Oh, Nick is sitting in here already.
Alright, this is number 15.
James Barker up here. Okay.
Thank you. Matter is on the calendar today to hear the motions to suppress that were previously filed by Attorney Robert. Mr. Barker, are you prepared to argue those then today?
No, I'm not. I filed some motions I filed a motion to object to arguing those motions because I filed.
What motions? I didn't hear you. Object to?
I filed a motion to object to arguing those motions. I filed those motions. What? What's the date?
It would have been January 10th.
I think it was before that, but yeah. I fired Attorney Robert Bucket and Attorney William Sultan due to my suspicion of them not being out for my best interest. And I tried to address the courts and let you know that I didn't want to argue those motions, but
Okay.
you told me I couldn't, basically.
So, is it your desire then to just withdraw those motions?
Yes.
Okay, very good. So, based on that then, the court will consider the motions to suppress filed by Mr. Bucket back on November 9th and the motion to suppress filed by Mr. Sultan that same day, November 9th, 2016, withdrawn. Mr. Barker has indicated a desire to proceed with those motions today.
Can I address the court, please? Okay, I couldn't, it's been on court record since December of 2015.
I'm sorry?
It's been on court records since December 2015 that I've been trying to exercise my right to view and inspect the original search warrants, and still I don't have all the discovery. So it will be quite impossible to argue affidavits and search warrants if I'm not provided with all the discovery. Now,
Well, let me just back up and ask you for some clarification there, Mr. Barker, because are you talking about these motions to suppress that we were just talking about?
period. In order for me to move forward and do any kind of proper investigation as far as arguing the motions to suppress, arguing the affidavits, I need to discover.
Are you withdrawing your request to have those motions heard at all?
Yes.
Okay.
Yes.
So, in other words, you're not asking that those motions filed back in November of 2016 be adjourned. You are indicating today that you are withdrawing them completely, just so I'm clear.
Well, actually, I indicated that about a month ago on record. I filed a motion. Yes.
Okay, you apparently filed a motion on January 10th when I was on vacation, so for whatever reason I didn't get it. But if your desire then is to withdraw those motions completely, then those motions are no longer on the table. That's what you're saying, correct?
Yes.
Okay. So I know when we were here on December 11th, you were to contact Deputy William Dale, I believe, to look at all the discovery. Has that happened?
Yes and no.
Okay.
Let's see here. I emailed, but in the beginning, it started off in December, I think, of 2017. December 1st, 2017. In the beginning, I was supposed to contact me and Haley Joe Johnson, we ran into Deputy Chia Petty in the hallway right after court. I was supposed to contact, and me and Haley Joe Johnson, we agreed to, Chia Petty, he said for us to contact Investigator Schultz or something, Ryan Schultz, I believe, not Ryan Schultz, Showman was his name. And so he advised for us to contact Showman in the hallway after court. And so Haley Johnson told me that she was going to contact Showman for me to view all the discovery and she would get back with me. That led to somehow me having to drive to Walworth County to get the discovery. But even before I drove up to Walworth County to get the discovery, I had already, on several dates, at least, I've been to the Racine County Sheriff Department, the Racine County Public Case Office, the Racine County Civil Case Office, the DA, Racine County DA Office, the Walworth County DA Office, all this to obtain the discoveries and view the search warrants with and without attorneys. As far as what she said, it went to contacting Showman, and then it turned into contact.
I'll place it.
If everybody in the gallery could please make sure that your cell phones are either silenced or off. My court reporter's job is to take down every spoken word, and when phones are going off, that's nearly impossible for her to do. Go ahead.
Okay, it led for me to suppose to contact Lieutenant Showman, I think it was, and then it went to contact Heather Spranger, and so I contacted Heather Spranger to view the discovery, and then Heather Spranger said she's not the evidence technician no more. Contact William Dale. So each of my encounters with these evidence technicians, I got it all recorded and also through email. It's just been a runaround. Just last month, I think it was the 13th, we went to, like you said, we went to the Sheriff Records Department to obtain the discovery that I've been asking for. And I got the email. I would like to read the email of me talking to the new evidence technician, William Bill. These are the specific things that I requested, that I've been requesting since 2015. I said, it's a long email, so I'm just going to break it down to you. I said, I specified in my previous December 13, 2017 email to you all the discovery I am seeking first. These items I don't need to inspect as of now. Please just prepare the requested evidence with a detailed receipt of all the items, and then place all the following requested items in a sealed envelope. On January 3rd, 2018, approximately 12 p.m., I will pick up the sealed envelope with the requested items inside, along with the detailed receipt. Afterwards, I will come back on January 4th, 2018, approximately 12 p.m. to inspect and review the additional requested original records and physical evidence on January 4th, 2018, around 12 p.m. If you can't be there on these dates and time, please notify me by email. So I gave him a detailed list of all the discovery that I was looking to pick up. And this is the envelope right here that when I picked it up, and they keep sending me the same documents over and over, documents that I'm not even requesting. I also filled out an industry because I can't afford to keep paying for these documents. I filled out an industry form so I can subpoena help pay for this stuff. But these are the details of the discovery I specifically requested. I said I want the April 23rd, 2015 audio recording of Deputy Brian Bansott interviewing Yvonne McNeil. The reason why I'm requesting that specific interview is because Investigator Brian Bansott, he wrote on page 4 of this 6-page report that he interviewed Yvonne McNeil on April 23rd, 2015, and it was audio recording.
It's April 23rd, 2015, audio recording of what?
Yvonne McNeil, him inside her home at 815 H Street on April 23rd, 2015.
All right. Ms. Johnson, do you have that video or audio?
I don't have it with me, and I don't have the list of all the items. The plan was for the defendant to go to the sheriff's office to obtain all of these things. I do know that Deputy Dale did contact him and told him that the dates they originally scheduled would not work. Deputy Dale gave him alternative dates and then never heard back.
Okay.
My understanding was the sheriff's office was trying to get all these items he needed, but there was no response back.
Okay, so they have the item, but for whatever reason, so you agree that he emailed you back, those dates that you indicated in your email weren't going to work for Deputy Dale, but he gave you some alternative dates?
No, that's not all. That's partial true. Now, if I can continue, everything is in. I got everything audio recorded and in email, all the facts. So she just giving me propaganda on what actually happened. I was down there at the window with the NAACP while I was requesting the record.
Sir, you always give me a lot more information than what I need to know. I just need to know whether that audio exists and whether the Sheriff's Department can get Mr. Barker a copy.
If it exists, they can get him a copy. I don't have the list. There are many discs, and I apologize for not having the full list. But Mr. Barker was told if he wants any audio recording, it would be a fee of $5 per disc for copies.
Can I continue elaborating on?
Yes.
Okay. So as far as what she's saying, I have been to the Racine County Felony Case Office. By order of you, I've been there. I've been to the Racine County Felony Case Office on several occasions. I drove all the way up to Walworth County. I went to the Racine County Civil Case Office. I've been to the DA office. All in pursuit of the exact same recordings and all that. And every time I come to court, it's well, we don't have it, and she act like she need to check her discovery packet and all that, and I never did them. So, but I would like to just read this email because these are all facts right here, and if you're interested in the facts, I can just read the email. So,
Do you have a copy of the email that
yeah, I filed it in
you
record.
gave to me?
I filed it. She should have a copy. I filed all this. All this is on the case number 2015 CF627. I filed them all.
The problem is, there's been so much filed on January 10th alone that I can't even discern what it is that you're referring to.
Well, I can read. I can sit here and go over it so we can
It would make it much easier if we can just make a copy and I can see what happened as opposed to you just reading it verbatim, Mr. Barker. Do you have any objection to having my clerk just photocopy the email that you're referring to so I have it in front of me?
I filed them so you guys will have a copy of them when I get here.
You filed so many things, sir, I don't know which one it is. Would it be the one marked Deputy William Dale email,
It's a few.
December 8th?
Yes.
There's another Deputy William Dale email, November 13th,
Yep.
December 7th.
Yep.
Which one is it?
It's all of them because that's going to tell you the whole tale of what she's saying. I contacted him. I even have a phone conversation recorded of me speaking with him. And so I would like to address the court and state on record all the stuff that's going on with these. We stopped at the first item that
Well,
I
I
didn't
can
receive.
see that Deputy Dale contacted you and said that he was not able to make your appointment because of a conflict, and he gave you Monday, January 8th at 11:30, or Thursday, January 11th, or Friday, January 12th. Did any of those dates work for you, Mr. Barker?
No, it didn't.
And then did you email him back?
No, I didn't. And I didn't email him back for a specific reason is he contacted me by email, read that email when he told me that I can come in and view the physical evidence, but I can't bring anyone with me. I can't open the evidence, I can't touch the evidence, I can't photo the evidence, I basically just got to go in there and just look at it and walk out of there. I can't record my encounters. I can't do any of that. And I also submitted the email from my first attorney, David Sedano. He went inside the evidence room with a private investigator. They photoed the evidence. They did all that. But now all of a sudden, that I'm my own attorney. Now I can't photo the evidence. I can't touch the evidence.
If Mr. Saldana already received it all those months or years ago, why don't you have it?
That's just one particular piece. That's referring to the TAC that investigator Brian Van Sock planted on the evidence on me 3 days after my initial arrest. And if we can elaborate on that too, because but I would like to go over this continue reading this email for the record.
Okay, Mr. Barker, these emails are pages upon pages long.
Yes, but I'm trying to get to the bottom of the discovery. We don't have to
We
read
need
all
to
the
get to
emails.
the bottom of the discovery so that we can finally schedule a trial date. All right, so it appears there's an April 23rd, 2015 audio recording of Ms. Is it Evan McNeil?
Yvonne McNeil.
Ms. Yvonne McNeil. Okay, what else?
Okay, Yvonne, the next one is, I want the August 21st, 2015 audio video recording of Deputy Brian Van Sock interviewing Josh Goldman in the presence of his Attorney General Servino.
I'm sorry, it's the August 21st, 2015 audio video recording of whom?
Investigator Brian Van Sock interviewing Josh Goldman in front of his attorney, Jennifer Servino. Last court date, we went through the same thing. You wrote it down. You gave the information. The last 2-3 court dates, we've been going through the same thing over and around. They asking for the same interview. I emailed the DA asking about it. I've submitted several discovery requests for the exact same
What's
recording.
the next item, Mr. Barker?
I would like to continue elaborating on this August 21st, 2015 interview with Josh Goldman. So as far as the interview, you co-signed for the DA. She said that this interview don't exist. And the reason why
All right, let me ask you this. Ms. Johnson, are you aware, and I just have to say this again, because Mr. Barker, you continue to assert that there are documents and things that even the state doesn't have. Things that don't exist can't be provided. Do you have this August 21st audio-visual recording, Ms. Johnson?
I do not. I do have an interview with Joshua Golden from April 23rd, 2015.
okay,
This is dated when? April 23rd?
Yes.
right now I'm holding on August 21st police report from investigator Brian Van Sock, and it's August 21st, 2015, and inside this police report right here, written by investigator Brian Van Sock, he states at the end, he said, the interview was audio and video recorded, and inside this police report right here, after reading it, it seems as if his goal during the interview was to establish a connection between me and Josh Goldman. This is an exculpatory piece of evidence that they're concealing from me.
Mr. Barker, do you have an April 23rd, 2015 interview of Josh Golden?
Not April 20th. I have that one, yeah,
Okay.
but not this August.
Is it the April 23rd recording that is being referenced in an August
No, it's not.
2015 report?
No, it's not. It's two different interviews. The interview, the April 23rd, 2015 interview is, I believe it was Van Sock interviewing, matter of fact, it wasn't even investigator Brian Van Sock interviewing Josh Goldman. I believe it was someone else, and there was no attorney present. Josh Goldman just he's describing everything that was said at the interview inside this police report. And in the interview, April 23rd, it was totally different dialogue inside during the interview.
Right. So you have, Mr. Barker, the April 23rd, 2015 recording.
Yes, I do have that.
And you have that as well, Ms. Johnson?
Yes, sir.
You do not, Ms. Johnson, have an August 21st, 2015 recording?
No, I do not.
Now, if you're stating that this interview don't exist, that means that they're concealing evidence.
Well, not necessarily, sir.
Why not?
Because, first of all, I can't say anything because I don't have the stacks of police reports that you have. I can't say whether it exists or not. But if Ms. Johnson doesn't have it, it may not exist.
So that means that the officer's credibility is at stake here, then, right?
Not necessarily. I don't know what those police reports say.
But I'm
And
trying.
it could be that August report that you're referring to is referring back to an April interview.
So you're
I don't
saying.
know.
So you're saying that on his, if that's the case, so he forced and backdated the interview.
Sir, you can't put words in my mouth like that. You try it every single time we appear on the record. I'm not saying anything. I'm saying the state doesn't have it, you don't have it, and therefore it may not exist.
So
What else are you requesting?
I would like to continue to elaborate on the August 21st interview because it's very important to me. It's exculpatory evidence, and this could mean a lot for us being found guilty or not guilty. And so I would like to continue, and I asked for audio and video playback equipment so I can bring forth the video evidence that I have now. See audio and video playback equipment in court right now. I motioned to court for those pieces of equipment. But so you're saying that it's August 21st. He took the time and typed out an August 21st interview. I can watch the April 23rd, 2015 interview that you're trying to say. Now all of a sudden this is the April 23rd, 2015 interview. And you're saying that, but everything he's describing to a T, what was said during the interview. I don't know, maybe it's a few things that left out, but it says that it was audio and visually recorded. Now, so you're saying that the officer can write a false police report.
I'm not saying anything of the sort, Mr. Barker. All I'm acknowledging is that you and Ms. Johnson both have the April 23rd, 2015 interview of Josh Golden.
But you did say
Neither of you has an August 21st, 2015 recording. That's what I'm saying.
okay, so I went to the place, to the legal custodian of the August 21st, 2015 recording. I went to, and that's supposed to be the sheriff department records. I went there, and they didn't have it. So now we back to this piece of paper. What is this, a lie, or, I mean, where we stand? So I'm supposed to read this interview and act like it don't exist because she's saying it don't exist when it's potential exculpatory
What
evidence.
else are you requesting, Mr. Barker?
Okay, I want an April 23rd, 2015, 7:45 interview of me, James A. Barker, by investigator Donna Vandervest. And this report, August 24th report, is investigator Vandervest describing that he interviewed me in the LEC building at 7:45 a.m. I do know I had that interview, but I just don't know the officer who was interviewing me. And you and Haley Joe Johnson told me that don't exist, and I'm the guy who sat there and interviewed, so I know it exists.
What is the date on that interview?
April 23rd, 2015.
And that one, I do have in my file, that would have been available to the defendant.
Well, it wasn't available. I specified that I needed that interview in this email, and it wasn't there when I went down there to pick it up.
All right, so Ms. Johnson, you have it.
Yes.
All right. So, Mr. Barker, the Sheriff's Department should be able to provide you with that.
So what about the industry? I can't afford to keep paying for this. I don't have a job. I'm not allowed to work because I keep getting dragged back and forth to court. And so how am I supposed to keep paying for this stuff? I filed an industry form. You never even responded to it.
We can probably take it out of the bond that's being held in the court. These are $5 per disc for copies, is that right?
Yes.
All right, what's the next item, Mr. Barker?
Okay, I want the April 29, 2015 email and response from investigator Brian Van Zyk to Landmark Credit Union Security Director Jeff Frank.
Hold on.
I would like to elaborate further on
It's
that.
from investigator Van Zyk to
Yes.
whom?
And he's also the applicant to these fabricated forward search warrants.
April 29th email from the investigator to,
No, it's April. I want the April 29th, 2015 email and response from investigator Brian Van Zyk to Landmark Credit Union Security Director Jeff Frank.
do you have that, Ms. Johnson?
That one I'm not sure of. If we do, that would be very easy to get to the defendant. It could be scanned in email.
Now I'm going to further elaborate on that. This is where the conflict of interest fall in with you because your signature is on this alleged order of the court and it's 2 versions, Wisconsin statutes. 89.07 says that a copy of a record is supposed to be a photocopy of the original, and this document right here has your signature on it, and this one got your signature on it, and as you can see,
Is it a warrant?
No, it's an order of the court with your signature on it, and it's not even filled in. It's not even certified by the clerk of courts.
What order is it?
It's the order alleged to my Landmark Credit Union bank records, but Landmark Credit Union, I spoke with the manager and they said this never happened. I even brought my bank records. This right here is supposed to have frozen my account. It even says it in the affidavit. And I brought my bank records to prove that my bank accounts was never frozen. And I also have more supporting evidence to prove that this the affidavit support and subpoena document is fake. It even says on the also the clerk of court said it don't exist either. The legal custodian. Let's see here.
Do you don't know that you have that or not?
I believe this has previously been addressed with Attorney Sultan. What the defendant is claiming is that the clerk of courts doesn't have the originals. I believe he thinks that since the clerk
So this is a search warrant issue?
It's all that. It's all kind of issues.
it's either a subpoena or a search warrant, the court signed it, it was filed, but the clerk of courts didn't retain an original. However, the defendant has copies that have the clerk of courts date stamps.
So they have copies.
No, I don't. None of this has a clerk of court stamp on it. It's supposed to be all. That's law. It's supposed to be filed in the felony division. It's supposed to have the clerk of court, Racine County Circuit Court. This is not even authenticated, and this right here don't even have the signature on it. It also says that it's for the unlawful use of a telephone. This is for bank records. You see that? So if the judge did sign the order, she obviously didn't even read it because it says for the unlawful use of a telephone. Also, I have the search warrant this that, not to finish elaborating. Also, I have the search warrant this, where these came from. My attorney, David Sedana, picked up a blank search warrant this from District Attorney Patricia Hansen on June 23rd, 2015, nearly 3 months after the search warrant was allegedly executed and returned to the clerk. So, when you pop the disc in, I have a video to display that to you. It's nothing but blank search warrant templates on the disc. So my question is, if the search warrants were signed, ordered, and affidavits were signed and returned to the clerks, why is my attorney picking up blank search warrants, this is one of them from
Once again,
the DA?
Mr. Barker, I need to kind of rein you in. First of all, you started out looking for an April 29th, 2015 email in response from investigator Van Zyk to Landmark Security
Yes.
Director Mr. Frank.
Yes.
Is there such an email, Ms. Johnson, that you know exists?
I don't know if it exists or not.
Are.
According to, I believe, page 5 of Investigator Van Zyk, backdated 6-page report, this email do exist.
I will have Ms. Johnson double check to see if she has it.
Also, when it comes, as I say, like, it's common law for, and Racine County Circuit Court rules Section 6E, 6A, all papers must be filed in the felony division. In Wisconsin statutes 19.35, I have a right to inspect. Me and my attorney went down to the clerk of court's office, the DA office, and the civil case court's office to see these documents. And the clerk of court and the felony case manager told us that the documents don't exist. And it's kind of strange that these documents only existed while I was incarcerated in jail between the months of April and January 4th, 2016. Only my attorneys while I was in jail was able to obtain these documents, and since I've been out, none of my attorneys have been able to obtain these same documents. So that they're kind of...
Well, Mr. Barker, if your other attorneys have this April 29th, 2015 document, then again, why aren't you getting it from that lawyer?
Because that's not I'm supposed to be able to get it from the legal custodian of the original record, which is Racine County.
Are you telling me that one of your many prior lawyers had this email?
I have one email.
The April 29th, 2015 email in response from Investigator Van Sock to the Director of Security at Landmark Credit Union.
No, I'm getting this information from the supplementary reports, the fabricated supplementary reports by Brian Van Sock.
So you don't know whether any of your attorneys had this specific email?
Well, according to the motion to compel discovery and all the discovery I got, no, they didn't.
Okay, all right. And
No.
Ms. Johnson may not have it. She'll check on it. Next item.
Okay. The Landmark Credit Union bank records allegedly returned by investigator Brian Van Sock on May 7, 2015 at 9:45 $100. Now, he claimed he returned them to the legal custodian and the clerk of court, but they say they don't exist.
Do you have Landmark Credit Union bank records for Mr. Barker, Ms. Johnson?
Again, I'm not sure. I know there was a request for those records, and I've provided everything I have in my file to Mr. Barker. I can double check on that. Again, the reason I don't have a lot of these things for him is because I had hoped he would schedule that appointment with the sheriff's office so he could have access to everything in the file instead of going through this same exercise.
Well, that's what I did, and that's what this email is describing. I gave him the list of specifics, and I went to pick him up. What's the problem?
The problem is that Deputy Dale gave you alternative dates to which you never responded. And so it's like a Groundhog Day movie. We're back on the same issues every time because you're not able to schedule a meeting that's mutually acceptable with you and the sheriff's
We
department.
did that already. The second email that he sent me, as I described, he told me I couldn't forward, touch it. But first of all, it'd be redundant for me to go down there if I can't come out first. Once I already feel like my life is in danger and I'm scared of my life to be going in back, if they write all these fake reports and search warrants and
Mr. Barker, you know, I understand the theory that you're proceeding on here, but really, all right.
Can I continue? As far as me going down there, this list that I am reading off, I specified what documents that I wanted to pick up and for him to place inside this envelope.
I'm not seeing it in the chain of emails.
I'm reading from it. This is the email. Everything I said, I specified in my previous, so look at the December 13th email first, and then I gave him the exact same list, and I'm just reciting what I wrote in the December 13th, 2017 email.
There's an email December 13th regarding Deputy Heather Spranger. Is that the one you're referring to?
Maybe so, but at the time, she was the evidence technician, and every time it's time for me to go through discovery, it's all of a sudden it's a new evidence technician. So I'm just ping-ponging around the Racine County Justice Departments, and records departments. Every time I get ready to go to discover it's somebody else, I'm talking to the wrong person. Like I said, I got everything recorded audio. I'm trying to present it to the people, but I'm not allowed to afford the opportunity to do that.
In none of these emails am I seeing a clean list of exactly what you are requesting. So let's just proceed and we'll get.
Can I continue to read this list, please?
Okay, you said you wanted Landmark Credit Union's bank records. When were those allegedly received by the Sheriff's Department?
Well, they was returned to you, so you should have information on that.
Nothing is returned to me personally, Mr.
Well,
Barker.
according to
When were these bank records received by the Sheriff's Department? When were they, let me ask you this, when were they requested?
Well, Brian Van Stock right there, he probably can give you the information. But according to the fabricated order of the court and subpoena for records, there was
When was
return
the order dated?
on April 29, 2015. And it was allegedly returned to the legal custodian on May 7, 2015 at 9:45, $100.
When?
At 9:45,
May
$100.
what? What was the date? May 9th, did you say?
May 7, 2015.
Okay. What else?
The eBay records submitted to investigator Brian Van Sock from Creek Counsel, Kristen Chapman, on or before April 22nd, 2015, and all the correspondences involving Kristen Chapman and the Sheriff Department. Now, my whole case involves around these alleged eBay records that was supposed to state that I made $90,000 selling eBay products. Now, they did provide me with these.
Stop for just a minute. I know that there were eBay records. Those were previously provided to Mr. Bobbitt?
Yes.
Okay.
No, those are not eBay records. Those are Terapeak. Well, Terapeak and eBay is not the same. And also, those Terapeak records that was provided to Vince Bobbitt are dated after April 22nd, 2015, the day that the fabricated affidavit was allegedly sworn to. So, if you're giving me some documents, the probable cause for the search warrant was based on this information, and you're not providing me with the information that's used inside to convict me, prosecute me, send me to trial, they're not, and also put me in the front page at the biggest stuff in Racine.
Sir, please, let's stop pontificating and just deal with exactly what you need. eBay records. I know the state has had them, and I know we've gone over this before. Those were previously photocopied and given to Mr. Bobbitt.
They were either photocopied and given to Mr. Bobbitt, or Mr. Bobbitt had the opportunity to review them.
I can read this email from this letter from Attorney Bobbitt to Haley Joe Johnson, and he's describing that he never got the discovery from Haley Joe Johnson. If I'm afforded the opportunity to
With
read this.
respect to the eBay records that you have in your possession, if you would please photocopy those again. Whatever the bill is, we will take it out of the bond that's being held for, that was posted by Mr. Barker.
I'm not spending my bond money on nothing that I already have copies of. I have those.
Do you have the copies of the eBay records or not?
No, I do not have copies of therapy documents that was given after the execution of the warrant. And
Stop. Do you have the eBay records in your possession? We're talking about the eBay records.
No.
So you need copies of those.
Why is you charging me for it?
Because there is a cost to reproduce
Okay,
them.
all right, yes. Okay,
So,
I understand.
she can reproduce them, whatever the bill is. Walworth County will be reimbursed out of the bond posted.
How is Walworth County being reimbursed if Racine County is the,
Because she has them in her possession in Walworth County, she will be having her staff make copies of everything she has with respect to these records, so the cost is hers.
Is it true that this case is a Racine County case?
It is true, Mr. Barker, that
So-
this case is venued in Racine County because the special prosecutor is from Walworth County, the cost is hers.
That's not how the
So Ms.
statute
Johnson
states.
will photocopy.
Okay, so I drove to Walworth County after these records before. I got it on video recorded, audio recorded.
I
And it
understand.
was after the exact same records, and now you're trying to drain me from my resources by spending all my bond money on documents that don't.
Sir, if
This is
you
crazy.
still, I know, because Mr. Bobbitt appeared in court with you,
So,
that you went to Walworth County with Mr. Bobbitt. Mr. Bobbitt obtained copies of everything. If for whatever reason he didn't give them to you, you are entitled to them.
do you want to see the video of this attorney, Vincent Bobbitt, stating on video that we drove up there for nothing because the documents we went up there to get wasn't in the folder that she allegedly provided?
She will provide them, she will make copies, and we will deal with those charges. What's the next thing you need after eBay records, Mr. Barker?
I want the inventory item number 15, credit union identifier belonging to the defendant James Howard.
Repeat that, inventory number,
15. See, these fabricated right here, these are fabricated property inventory sheets. The time's missing, anything to do with time.
what is it specifically that you are looking for, Mr.
Let me
Barker?
see what number 15 is on these. It says, oh, I got that. Landmark Credit, no. It says Landmark Credit Union to James A. Barker III. As far as these, I think I got, that was one of the several things I requested that was in the folder. That I've been trying to get. That was there, and I want to elaborate.
Is this different than the April 29th, 2015 email?
No, the significance of this piece is because they're charging me with THC that was found, allegedly found in my girlfriend's apartment, and the reason why they're saying they're charging me is because they found a Landmark Credit Union bank on Landmark Credit identifier with that address on it. I got the Landmark Credit identifier.
So what you are actually looking for is an identifier, hold on,
I got it. I'm telling you, I got it right now. And I want, that was one of the things that they finally gave me. And
so you have it.
yes, and inside the criminal complaint, they're using that identifier as a reason for charging me with marijuana that's in somebody else's house that really wasn't in somebody else's house. And they saying my name, the reason why they was charging me with it is because my address was that address was on the identifier, and my PO box is on the identifier.
So you have that identifier.
Yes, but the officer again lied in his report.
You have it.
Yes,
You don't need it provided to you again.
I have that.
Okay. I'm going to cross that off the list. What next are you asking for?
I want the Western Union. Okay, I want the items number 16. That's something he did. That was inside the envelope. You see that he wrote the receipt on the back of the envelope, all the evidence.
So whatever, it's a Western Union identifier?
The Western Union, I got that.
You have it.
That was something that they finally gave me.
Okay.
And those two identifiers were allegedly linked
You
to that.
have it.
Yes,
You don't need it. Next item that you need.
I want to elaborate.
Disparities. And the law is that even if duplicates of the original search warrants were filed as opposed to the original documents, there's nothing to indicate that your substantial rights were affected, and therefore those copies suffice.
Yeah, that's only if the warrant is upon audio or like telephone, but any warrant upon affidavit is
That's
original.
not true.
That is true.
Technical irregularities are discussed in State versus Nicholson, 174, Wisconsin 2nd, 542, State versus Rogers, 315, with 2nd, 60, State versus Rafflick, 248, Wisconsin 2nd, 593.
Well, look at
Those
state.
are the cases that govern, and so that's now a non-issue. The copies of the originals suffice. Let me ask you this. Do you need additional copies of the originals?
No, I do not.
All right.
The original warrants under Wisconsin Statutes 968.12, a warrant upon an affidavit. First of all, the search warrant is supposed to have, if these are copies of the originals, it's supposed to not only have the judge's signature, so which one is the original? If I got 4 warrants to my house, right? So you're saying that it's supposed to be a copy of the original, or they can just have a copy of the original. So how do I know? If there's 4 different versions of the same warrant, which one is the original? Even the ones got different issue dates on. One day April 23rd, 2015, which was the morning of the raid. One day June 23rd, 2015, which I was in jail. I don't even know if my parents still lived there at the time.
So what you're saying is that you have all of those copies?
I got all of these uncertified copies. They're not even in color of the Wisconsin statutes warrant upon affidavit. And they're also the affidavits to the warrants and incorporated with the face of the search warrant. On the face of the search warrant, it's supposed to have the judge's signature, the time of execution.
These are arguments that you can make, but my question to you for today, do you need any additional copies of those documents? Sounds like you have them all. All right, let's move on.
I filed 2 motions. I filed a motion to change the venue because it's clear that I'm not going to get any justice in your courtroom. It's 4 search warrants according to Brian Van Syk that you signed. It's in a 6-page April 24th backdated report that you signed. I never even saw those search warrants. I got some search warrants, but I don't have all of them. So that's the reason why I'm asking, hey, bring forth the original search warrants so I can, because I got about, it's about 30-some warrants. It's 16 signed, 16 unsigned, and there's other warrants that's being mentioned inside police reports that I've never seen. The search warrants are missing, some of the search warrants are missing pages. Some of the search warrants are missing warrant returns. None of the affidavits to the search warrants have a notary seal, and that's mandatory by Wisconsin law 137.01 section 13701 section 4 attestation. It said that all affidavits must have a clear impression of a notary seal. So none of these affidavits have a clear impression of a notary seal, and that's the reason. That's the whole reason for the law that you're supposed to have a photocopy of the original. And Supreme Court ruled that Wisconsin versus State versus Ty, and also City of Racine LLC versus Thomas Holmes, same issue. A warrant upon affidavit is supposed to have a notary seal and is supposed to be properly sworn.
Anything further on that, Ms. Johnson?
Your Honor, my response being the defense argument is incorrect, merely that an original warrant has not been provided and is not sufficient grounds for a change of venue. It is not the grounds that I asked of the court tonight.
It's not grounds for a change of venue. It's not grounds for me to disqualify myself. The fact that I may have signed 1 or more of the search warrants in this case, Mr. Barker, is not a reason for me to disqualify myself, and I won't do that. All right.
What about the search warrants, the 4 search warrants that was allegedly written by? I never seen them. Can I get copies of those warrants?
Which warrants, sir?
I'm pretty sure y'all gonna make them. So according to Brian Van Syk's 6-page report, never mind those warrants because I ain't gonna get no justice anyway. But
what copies of search warrants do you still need?
It's 4 warrants that, according to a 6-page report, let me find it where he said, he said that approximately 750 hours, investigator Nelson, investigator Doe, Sergeant Cole, Deputy Druid.
Sir, you need to slow down, please. Slow down, start reading again, but slower.
At approximately 750 hours, investigator Nelson, investigator Doe, Sergeant Cole, Deputy Druid, and myself conducted a search warrant at Barker. Thank you, Department. Oh, yeah, this is, okay.
Just give me the date of the search warrant and where the search warrant was executed, sir.
The search warrant was allegedly for my Dell laptop computer, my Apple desktop computer, my LA View surveillance equipment, and let's see, Apple. Okay. My Dell laptop computer.
Was that the search warrant executed at Ms. Burnell's residence?
No, there wasn't a search warrant issued at. It was alleged a consent to search form that she allegedly signed. I have a copy of that consent to search form, but even they have writing from an officer that claimed that he wasn't even there on the consent to search.
What's the date of the search warrant and the location of the search warrant that you need?
Please, of course. Please, please. I keep on telling everybody the same thing every time.
Here you go. It says on May 14th, I prepared a search warrant to brush reserve Apple desktop computer, the LA View DVR video surveillance system, seized from 1412 West 6th Street, and the Sands DVR video surveillance system, seized from 2310 16th Street. The search warrants were approved by Deputy District Attorney Hanson and signed by Judge Flancher, which is you. I never seen those ones. Also,
So, what location was it one search warrant or more than one search warrant?
It's the report of Van Zoxel. You would probably be able to tell you better than I could, but I guess it's 4. I never seen them. And looking at the unsigned runs with the wrong date, because I do have search warrants to these devices with no signature with the wrong issue date, and they all came from that search warrant disc that Patricia Hanson gave Attorney Davidson Donna. But the actual search warrant signed search warrants themselves is still missing from discovery. And the legal custodian said they don't.
So you are saying there are 4 search warrants dated May 14th of 2015?
Yep.
And they were for your Apple computer. What else?
My Apple computer, my dad's LA View surveillance system, my Sands DVR surveillance system, and yep, those 3 items. but investigator, Vandervest have a contradicting report to these same items where he's returning these same search warrants to the exact same items before this report was even. For instance, this police report is dated April 24th, 2015, but on here he wrote on May 14th, 2015, I prepared a search warrant. So if you wrote this report on April 24th and you handed it in, how are you talking about stuff that happened several weeks later? That just shows that this is backdated. And he went back and re-edited the report.
Did you have more than one Apple computer?
No, but
So wasn't the computer that was seized, the computer at Ms. Bernal's residence?
yes,
All right, so that search warrant then you have.
no, I have several. It's like
There was one computer that was seized at Crystal Bernal's residence. So, and that search warrant was apparently for the computer only.
no.
You have to have a copy of that.
I do have a copy. I have several other copies of search warrants that was alleged to the same advice. Some signed by you, some signed by Judge Constantine.
So, okay, so you have the search warrant for the Apple computer. The search warrant for the,
For instance, this search warrant right here is to the Sands the Sands surveillance equipment. Now, it's a no-knock search warrant to a piece of surveillance equipment. And it's unsigned, and it says.
I just want to make sure, sir, because these may be three separate search warrants and not one search warrant as you are representing.
I'm saying it.
The search warrant for your computer was directed to the computer in the home of Crystal Bernal. So that search warrant you already have.
That's not a search warrant, that's a consent to search.
Okay, so she consented to search and your computer was then taken.
Yeah, my kid's computer was taken.
So now, so you have that. So now you're looking for specifically a search warrant for your father's surveillance system and your DVR surveillance system, which would have been at two different addresses, correct?
Actually, three. It's my store, 2310 16th Street, Crystal Bernal's resident, which was a consent to search, and that's 2714 16th Street, and also 1412 West 6th Street. Now, it makes no sense if you're saying that they only need one warrant.
I'm not saying that, I'm just trying to figure
Okay.
out what you need.
Okay.
It sounds like you already have what you need for your Apple computer. So what you are still saying you need is something governing your dad's surveillance system and your surveillance system.
No, I do not have the search warrant that he's referring to in that police report to my Apple computer or any other device, any of the three devices.
So that was my question.
Yeah.
There was only one Apple computer seized.
Yes.
That was at Ms. Bernal's residence.
Yes.
Why would you think then there would be any other search warrants for a computer if there was only one computer?
Because I'm looking at them right here, like this. I'm looking at the search warrant. At the report saying we have this search warrant, and it was returned to the clerk. So if he's saying that the search warrant was signed by you and returned to the
One
clerk.
of the issues with respect to Crystal Bernal, and this was raised in Attorney Bucket's motion in November of 2016, because the motion stated that a search warrant was executed at 2714 16th Street. That is not Ms. Bernal's address. There was no search warrant executed at that address. Ms. Bernal lives at 1274 16th Street. So numbers were transposed somehow.
Mm-hmm. Well,
So
it's
the
20.
only search warrant then that was with respect to the computer was that at 1274 16th Street.
That's not a real address. That is 2714 16th Street. And it was a consent to search. She allowed the police to come in the
Okay,
house.
so then that's not even an issue. So again, what you are asking for then is some search warrant regarding your dad's surveillance system and your surveillance system. Is that right?
No. It says here, listen to it. On May 14, 15, I prepared search warrant for Barker III's Apple desktop computer. So therefore, there should be a search warrant that says May 14th as the issue date
No,
and signed.
that's not what it says. If he prepared a search warrant on May 14th,
Okay.
that doesn't mean it was issued or executed on that date. So that's what I'm trying to get at. What you need is the substance of a search warrant regarding your father's surveillance system and your surveillance system.
Listen to this. It says the warrant was approved by ADA Ricochet, signed by Judge Flancher, and given to investigator Mihalik for download. So, yeah, it was issued, it was signed, approved, and given. So,
But it's not necessarily that May 14th date. That's my point.
okay.
All right, so it sounds like these are documents you already have.
I don't have them.
Ms. Johnson, if you would get copies of the search warrants regarding seizure of the surveillance system, Mr. Barker's father's surveillance system, and defendant's surveillance system at the home address and address for the business. Yes. All right.
Before I'm charged anything, I would like to know. I like to see what I'm getting because I see where we're headed now.
Okay, you know, it's important that you get this stuff.
Mm.
But
Now-
you can't now say, I demand, and then say, oh, well, now I'm not going to receive it because I'm not gonna pay for it.
I mean, all these documents that I got, my attorneys was giving to me. Now all of a sudden, it's a price tag on everything. It just ain't sitting
It
well.
wasn't given to you for free. That was taken out of any retainers that you would have paid your lawyers, sir. Okay. What else do you need?
I need to argue my motion that I filed. I filed the motion to change the venue.
I've already denied your motion for change of venue, and I've denied your motion to disqualify myself.
Do I get a chance to present my evidence?
I've read your motion, and your motion is frivolous, sir. You state no legal basis for me to recuse myself, and you state no legal basis for a change of venue.
I did state legal basis. That's why we're supposed to state the record. Let's go over this and let me present my evidence on
What
why
else
you
would
should
you
be my
like to
attorney.
say? First of all, before we do that, is there anything else you need in terms of discovery?
I need, I need everything that the officer's saying that, see, they're using all this stuff. They're saying, we got this, we got that to prosecute you, to bind you over
I am
trial.
going to prepare an order based on what you said you needed today. And we'll come back to make sure that that order is complied with. What other arguments do you want to make for the completeness of the record on your motions for a change of venue and your motions to disqualify me as the presiding judge?
I have no argument, but look, I have this letter right here from attorney, now Judge Mark Nielsen. You guys are stating that they do not have to provide me with the original search warrants under whatever case law. This is a letter from my attorney that I had while I was in jail, and he's describing picking up all the original search warrants from the felony case office right here in Racine, right outside this door. He said all the original ones. Once I beat my revocation hearing and bonded out, I went to that exact same window he's describing in this 2-page letter of picking up these search warrants that he allegedly got the copies from that he gave me. And they saying the search warrant don't exist and that never happened. I'm trying to present, I video recorded and audio recorded these events. And they also told my new attorney that I had, Tony Young, that the search warrants don't exist. So he's saying he got them from that office. So y'all trying to use some kind of motion that's saying, hey, we don't have to have the originals. But I got the attorney in writing and in video saying the felony courts got the warrants.
All right. So presumably then, when Attorney Nielsen, now Judge Nielsen represented you, you would have received all of that documentation?
No, I didn't. A lot went on, which what led to me firing him. He was trying to. It came clear to me that he was trying to cover up something, and so when I first tried to fire him, and I was told I couldn't fire him. So the way I fired him was I wrote to the administrative law
But I
judge.
don't need to know any of those
Right.
details. Anything further on that, Ms. Johnson? All right, we've already discussed, sir, the whole issue of the technical irregularities. I don't know what else I can even say on that. Anything else you want to address today, Mr. Parker?
Yes. How did a technical irregularly, however you say it? Why none of this significant to you? Like, I got an attorney, he's a judge now. This is his handwriting, this is his typing, this is from his office, Schwartz, Toffee, and Nelson. He described me in his letter, I understand you want to find him. I suggest you wait until we know whether the probation held will be dropped. I contacted Ms. Gasson and made our pitch for an ATR. She is talking to her supervisor, obviously, if there is no more hold, that enhances your argument on bond. Continued revocation hearing. I was not able to get the continued revocation hearing on this December. They had the 23rd available, but Janella was on vacation. The best I could do is January 25th, 9. Search warrants. I went through all the search warrants and returns filed with the clerk of courts. There is no activity after May on 2015. And I also have him under oath on August 3rd during our arbitration dispute. He said he testified under oath. On August 7th, 2015, he spent the entire morning right here in the felony case office going through all the original search warrants. And I'm prepared to play that one.
I don't even know how to respond to that. Whatever the court has, you would have received copies of. Whatever.
My response to that is he's saying that he spent the legal custodian of the felony case. He said he was there on December 7th and spent the entire morning going through all the original warrants. And he said this under oath. And I went to that same place, felony case. I talked to Amy Vanderhoff, Caitlin Presser, Victoria Warden. I've been there so many times I know by their first and last name, trying to get these same records. Paula Hyman, Jamie Hardin. We know each other very well now.
All right, let's get a date to come back in a couple of weeks to ensure that discovery is complied with and a trial date can be set.
Will I be able to, I motioned the court for a video playback equipment. I got the officers violating my 14th Amendment right, executing the unsigned search warrant on my property with, and there's no copy of this search warrant. Will I be able to present my evidence?
Sir?
I would like to present my evidence that I've gathered during my independent investigation. I have sworn testimony from Mark Nielsen. I have written evidence from prior attorneys.
What would be the purpose of presenting that? What is your motion?
My motion is to, I would like to get out of your courtroom, but I see that's not going to happen. Motion to dismiss.
Your motion to dismiss was previously heard and denied, sir.
When was this?
It was heard back in fall of last year. Did you file another motion to dismiss?
Who is this? I ain't filed a motion to dismiss. I can play you my attorney saying, we're not going to take any action until we file a motion to compel. I did file a motion to dismiss on July 24th, and when I came to argue that motion, that's when you made me go have a competency hearing. You refused to hear the motion. I tried to subpoena Yvonne McNeil. She also submitted a 6-page sworn affidavit stating that proving that the search warrants are false and fabricated, and you won't hear her testimony and the sworn testimony. I got all the evidence to prove that the search warrants are fabricated, but you won't let me present my evidence in court.
All right, I misspoke. So your motion to dismiss, there are so many documents filed.
Yes.
July 26th of 2017. That's the one you want to argue.
Yep,
All right.
but I'm gonna update it now. So yeah, I argue it's gonna be basically the same one, but so much has happened since July. 'Cause remember when I came here and I tried to,
When are you going to be filing a new motion?
I'm, when the next, probably the next 72 hours. So you can just give me the date, it'll be ready.
All right, let's get a motion date then. Does that conclude the motions then?
I would like to hear my motion, well, that went through, but I wanted to state it on record, but obviously you read it, but you read nothing else. Yeah, I filed a lot of documents, and a lot of those documents is exculpatory evidence, but of course never really pay attention to them.
Well,
because
sir,
it don't fit
it's
the
not
narrative.
my job to look at this evidence. It's my job to rule on it at trial. So all of this stuff that you have filed you filed it, so it's filed. But it's not my job to render an opinion about it.
I understand that, but it's your job to make sure that my constitutional rights is being protected in here. And when I came here prepared to argue the July 24th motion, right? That was the day when all of a sudden I needed to have a competency hearing, and you refused to let me argue the
All
motion.
right, we're scheduling your motion to dismiss. And then it looks like, based on all the documents that I've gone through since then, all the other motions to suppress have either been heard or now withdrawn.
Well, I
The
don't,
motion to change venue has been denied, and the motion to recuse myself has been denied. So this would be the only other motion, correct? Your motion to dismiss.
well, no, I will be filing a Franklin versus Delaware motion. So I will, the reason why I filed the indigency form is so I can subpoena the officers and the witnesses into court to testify. In which I already subpoenaed the majority of the officers to my revocation hearing, and they didn't show up.
Can you file these motions by Friday?
I'm going, since you gave me a date, I'm going to be working on it around the clock.
Well, tell me when you can get them filed by.
I will definitely have it done by Monday.
All right. If he doesn't even file it until March 5th, Ms. Johnson's going to need time to review it, to respond to it, and so we're probably looking end of March, beginning of April.
I also will be filing a motion for a speedy trial as well. I was gonna say,
Well, let me ask you, sir, because once you file a request for a speedy trial, I have to schedule your trial within 90 days.
I understand that.
Are you going to be filing that on Monday as well?
Never mind that. I'll file it when the time I can give you.
I'm just telling you,
Yeah.
there's,
I know.
I have to schedule your trial done within 90 days.
I know.
I'm happy to do that.
Okay. What about the evidence as far as when it's time, like for instance, the August 21st interview, 2015 interview with Josh Goldman. So when I'm supposed to be expecting all this discovery from the DA?
Well, I am going to prepare an order today that copies of anything, and we're going to.
I just want the stuff I specified. I don't want a $1,000 bill for stuff that I already have. That's the thing.
Well, everything that you told me, that you listed on the record today, you are saying you don't have, that's what you want. So my order will be that within 30 days, the state make copies of that, provide it to you, prepare a bill, and the bill will be paid out of your bond that's being held by the clerk of courts.
So okay. I want the video surveillance, April 23rd, 2015. Now, I'm very familiar with how the surveillance boxes is basically a hard drive. And it works just like you put a USB inside of the hard drive and you can back up onto that hard drive whatever document, whatever video footage you want. So for them to do that, and they allegedly already have it on a flash drive, so the only thing they have to do is just copy that flash drive and have that waiting for me, and I'll be glad to pay the $5 fee.
All right, what you will be getting is the April 23rd, 2015 audio recording of the
Investigator Vandervest,
yes.
745.
No, Investigator Van Sachs.
I got that already.
Interview of Ms. McNeil.
Okay.
All right,
Yeah.
that was the first thing you requested.
Mm-hmm.
Second, August 21st, 2015, audio-visual recording of the interview of Josh Golden with his attorney, Jennifer Serino. You stated that you already, that the state indicated that they had an April 23rd interview of Josh Golden. But you claim there's an August 21st available too. So if they have it, they'll create it for you.
Right.
Again, any charges for a copy of that video, we'll just take it out of your bond.
So if they don't have it, that's
I
the
don't know
question.
if they have it.
All I'm saying is,
She said that she has An April 23rd, 2015 interview of Josh Goldman.
Okay, the guy who
You
wrote,
said you have that.
the guy who wrote the report is right there, ask him.
I'm not asking him anything. She will look for an August 21st audio visual recording. Then you wanted an April 23rd, 2015 interview by investigator Vanderbest. They'll look for it. If they have it, they'll copy it. You want an April 29th, 2015 email in response from investigator Van Sock to Landmark Security Director, Mr. Frank. You want the Landmark Credit Union bank records. You want eBay records. You want an April 29th, 2015 Crime Stoppers report, if there is one. You want chain of custody documents. You want to look at your father's surveillance system that's at the Sheriff's Department. You just need to make arrangements to do that. And you want search warrants relating to your Apple computer. Well, you already have that. You want your dad's surveillance system and your DVR surveillance system. So again, Ms. Johnson will have her staff make those copies, and the cost for any copying cost will just be taken out of your out of your bond. So I will prepare that order and then have the state comply with that. Motion made.
Senator, I am going to be applying on FIO. I will probably be back in May.
Okay.
So there are two options. One option is for someone else from my office to be appointed as a special prosecutor to handle this while I'm out. The other option is to schedule anything once I'm back.
When are you leaving?
I'm due February 5th. My doctor will let me know 1 week after that, so around February 12th.
Okay. And then you're not returning until,
I'm taking the 12th.
can you break someone else's sleep?
Yes.
Okay. So would that February 26th, did you say February 26th? March. 26th. And Mr. Barkley, does that work with you?
Sure, yep.
March 26th. We can schedule it at 1:30 or here, short 1:30, yeah. All right, anything else then for the record today?
No.